Welcome, everyone. Thank you for joining. This is the Legal Roundtable on Adjudicating Climate Disputes in a New Era, Implementation and Conciliation. My name is Rihanna Hoover, and I'm a Senior Associate in the International Disputes Practice at Debevoise in Plimpton, based in the firm's London office. We'll begin our session momentarily with welcome remarks from our co-chairs, who I'd like to introduce very quickly. So we have Catherine Amirfar, who is co-chair of the International Dispute Resolution and Public International Law Groups at Debevoise and Plimpton, and she's based in New York. And Camille Martini, New York and Paris qualified attorney in public international law and a lecturer at Laval University in Canada. So before I hand it over to them, I'll just briefly introduce our lineup of moderators and speakers. So moderating the discussion along with myself will be Crystal Tam, fellow senior associate at Debevoise and Plimpton in the New York office and also a member of the International Disputes Group. Alana Melinda Lancaster, lecturer and the inaugural head of the Caribbean Environmental Law Unit of the Faculty of Law at the University of the West Indies at Cave Hill, Barbados. And Nusrat Jahan Urmi, doctoral researcher at the Faculty of Law at Monash University in Australia. And our speakers, in addition to Catherine, will have Nicholas Swan, who's a partner in the Litigation and Dispute Resolution Group at Chapman Tripp in Wellington, New Zealand. Joy Reyes is a policy officer in climate attribution at the Grantham Research Institute on Climate Change and the Environment at the London School of Economics and Political Science. And Maria de Arcos Tejerizo is a Spanish qualified dispute resolution lawyer at the law firm Perez Yorca and an early career researcher in public international law. So with that, I'll turn it over to Catherine to give brief welcoming.
Thank you, Rihanna, and thank you, Crystal, and really thank you for all of your efforts organizing this excellent program. So it's a pleasure to be here with you on the sidelines of COP30. As I think you know, we, Camille and I together, are going to be exploring issues related to adjudicating climate disputes in a new era. So that's our topic. And part of it, as we all know, is the global community's grappling with escalating environmental challenges, understanding the role of dispute resolution in particular, and how dispute settlement options may be well suited to resolving the issue of climate reparations is more important than ever. So I think in my introductory piece, I'm just going to give some background on dispute resolution under the climate change treaties, and then turn it over to Camille to introduce the topic of climate reparations. So you are all very familiar with the United Nations Framework Convention on Climate Change, UNFCCC, and the Paris Agreement. These are, of course, the foundational treaties providing a basis for global efforts to combat and address climate change. What many may not be as familiar with are the actual dispute resolution clauses in those instruments. So I'm going to go through and kind of give you a sense of where the conversation in the global community lies when it comes to dispute resolution. So to start with the UNFCCC, which is basically adopted in the same form in the Paris Agreement, the dispute resolution clauses appear under Article 14 of the UNFCCC and Article 24 of the Paris Agreement, which adopts Article 14 in whole, where the disputes concerning the interpretation or application, and that's very much a term of art, but interpretation or application of these instruments will be settled first through negotiation or any other peaceful means chosen by the disputing parties. That's the framing. If negotiation or other means fails, the dispute will be settled through conciliation, unless both parties had previously submitted a written declaration that the dispute would be resolved by the ICCA or through arbitration. Very few states have opted for the ICCA or arbitration, so conciliation really is the default method of dispute resolution for most states if a dispute arises under the UNFCCC or the Paris Agreement. Those treaties provide that, and I'll just quote it, additional procedures relating to conciliation shall be adopted by the Conference of the Parties as soon as practicable in an annex on conciliation, end quote. Now that additional procedures, that step has never been taken in an annex. There's lots of reasons for that. There's obviously been very fulsome political attention to different aspects of the climate regime, financing, et cetera. But the dispute resolution conciliation just simply hasn't risen far enough on the political agenda, I think, to have actually triggered state discussions. So in that context, in February 2023, the International Council for Commercial Arbitration, or ICCA, one of the leading global experts on arbitration, convened a world-leading panel of experts in the field of dispute resolution and climate change to develop a draft conciliation annex. And that's co-chaired by myself and Annette Magnuson, and was dedicated to trying to facilitate in any way that these experts could what must be first and foremost a state discussion and state discussions as to what a conciliation annex looks like. So not a substitution of state engagement, merely an attempt to facilitate and add to the discussions. So after months of drafting, stakeholder consultations, the ICCA panel of experts basically generated a working draft of what a draft conciliation annex might look like. And that was in the fall of 2023. There's 25 articles of proposed procedures and a commentary, importantly, pulling from all of the relevant precedent, the various conciliation procedures that had already been taken place, and how that might relate in specific terms to climate change disputes. So again, still set out really a matter of state engagement on this in order to run a process to be effective. So that engagement continues to this day, and it really, I think, has been helpful for states through various presentations and getting a sense of what would actually be involved if there were to be high-level negotiations around a conciliation annex that get initiated. So I think that one last point I'll mention is that this work, I think, has become all the more important following the landmark advisory opinions on climate change by the International Tribunal on the Law of the Sea, the Inter-American Court of Human Rights, and of course, just this past July, the International Court of Justice. Because what those three opinions have done, and there will be more, I think, from international bodies, including the African Court, is really set the table. This is what international law looks like when it applied specifically to the context of climate change. What are the existing legal obligations, the UNFCCC, Kyoto Protocol, Paris Agreement, as a matter of customary international law, prevention of transboundary harm, due diligence, you name it. These are very fulsome opinions. But what that clarification does as to what is binding on states, not as a matter of political discretion, but legally binding on states, rises in the context of when there's a dispute, if states are meeting their legally binding obligations, where does it go? And that's where we think that the conciliation kind of aspect to this will really come front and center, and perhaps a way that it hasn't yet in the context of the COPs thus far. And one concrete example is, for example, NDCs. It's quite clear that they need to facilitate the ability of states to meet their binding legal obligations to mitigate GHG effects, negative adverse effects of GHG emissions. So the content of NDCs potentially could be subject to dispute. Is that something where conciliation then comes into play? Just one example, but you can imagine how that can play out. So I'm going to leave it there because I think there's a lot of very good and really amazing participants on this panel to engage further on some of the questions. But let me invite Camille to you, hand it over to you to give your introductory remarks. But thank you.
Thank you so much, Catherine. Very excited for the conversations that will take place here today. And thank you so much for having us. I'm joining from Belém. It's a beautiful day outside and very happy to be here. So let me say a few words. So the implementation of the Paris agreement and the fight against climate change raise important questions about state responsibility, accountability for present and future climate harms, and reparation. And climate impacts intensify. We've been discussing those at COP30 in Belém. And people, affected communities and states increasingly seek guidance from national and international legal bodies. Yet major gaps remain. Can international law respond effectively to the climate crisis, provide redress to these parties, and through what mechanisms? In the second part of the discussion today, we will be inquiring whether international and regional courts and tribunals are well placed and can indeed provide relief to parties in such disputes. We will discuss cases drawing on several fields of international law, state responsibility, of course, human rights, and the reception of these international norms into domestic legal systems as well. We will analyze how parties argue for reparations, how courts and tribunals evaluate these claims, and these would hopefully highlight the need for further clarity and the importance of dispute resolution mechanisms, including conciliation, of course, and then when necessary, litigation. We have been working for a few months with excellent scholars, some of whom were presented today and will share their research later on. And this has been part of a research project funded by the Social Science and Humanities Research Council of Canada that I want to thank for the support, and this is ongoing work, so hopefully we'll be able to share further results in the coming month. I look forward to hearing from them, and without further ado, I will turn the floor to Catherine right away so we can kick off the conversation. So thank you again, and I look forward for the thoughtful exchanges today. Thank you.
Great. Thank you, Camille and Catherine. So with that framing and background, let's kick things off with our first question to Nicola. In what ways might the ICJ, ITLOS, and Inter-American Courts advisory opinions on climate change, which Catherine mentioned, how might they influence dispute resolution strategies concerning climate disputes, especially in terms of what evidence is presented and what legal standards are invoked by claimants?
Thanks, Rihanna, and lovely to be joining you all. I think there's some really interesting developments that we can point to in terms of evidence presented and legal standards that the three advisory opinions have really contributed to. And the first one, which has received a lot of attention, is the role of the best available science and the importance of best available science for judicial determination of climate change disputes. All three of the advisory opinions have focused on the significance of high quality, well-established scientific evidence, and they have relied on the findings of the IPCC as being central to the reasoning in all three of the opinions. The ICJ expressly recognised that the IPCC's reports constitute the best available science on the causes, nature and consequences of climate change, and so to have that confirmed at that international level is very useful. That, of course, reflected the position taken by the overwhelming number of states who made submissions in that fora and who were relying heavily on IPCC reports in their submissions to the court. The Inter-American Court of Human Rights also recognises in its decision that best available science must be consistent with Indigenous and local knowledge, and that is something that we're seeing arising in domestic court jurisdictions all over the world, and New Zealand, where I'm speaking from now, is one example where Indigenous knowledge is receiving more and more attention in all sorts of fora. So that development you can see converging in these opinions and also in domestic courts. One of the other really key areas of focus in terms of legal standards that the advisory opinions recognised is in relation to due diligence for states' climate change obligations. So the high standard of due diligence expected and the stringency of that due diligence. Effectively, this is the mechanism that the courts are recognising that by which states should be preventing significant harm, employing due diligence in their regulation of emissions and climate, and using due diligence as a guiding principle that flows from the international decisions into the domestic court application of those decisions. And so both ITLOS and the ICJ recognised that given the significance of the threat of climate change, the standard of due diligence for preventing harm to the climate system is a stringent standard. And the ICJ recognised that where scientific evidence recognises that it is highly probable that significant harm will occur, then the due diligence standard is even more demanding than it would otherwise be. One of the other key points in terms of evidence presented and legal standards coming out of these opinions, and this is particularly the ICJ opinion, is the significance of the 1.5 degree commitment at international law under the Paris Agreement. The court, one of the more interesting aspects of the ICJ decision opinion is that the court interprets subsequent decisions of the meetings of the parties in the international climate negotiations as being subsequent agreements under the Vienna Convention on the Law of Treaties, such that the court determines that 1.5 degrees is the parties' agreed primary temperature goal for limiting global warming under the Paris Agreement. And so we can see that determination very likely to be picked up and used as this baseline going forward from that very clear statement from the ICJ advisory opinion. Just one more remark, conscious of time, in terms of the significance of legal standards is the relevance of customary international law. And this is something that we can pick up in the discussion in terms of duties alleged against states. One of the other very significant aspects of the ICJ advisory opinion was the focus that the court had on the significance of customary international law and those customary rules applying alongside the obligations that are set out under the UNFCCC, the Paris Agreement and UNCLOS. And we can see a similar focus in the Inter-American Court opinion, recognizing the right to a healthy climate as an independent right derived from that right to a healthy environment. And we can see references to customary international law coming from the ICJ advisory opinion in particular already in some of the cases that are being that are citing the ICJ opinion against states. And if we have a little bit of time later in the session, we can look at a couple of those. Thank you.
Great, thanks, Nicola. So against that background, Catherine, do you foresee a convergence or maybe fragmentation among different international jurisdictions, so tribunals, human rights courts in international arbitration when it comes to addressing climate-related claims?
I will give that very lawyerly and unsatisfying answer. It depends. I think honestly, the answer is different domestically versus internationally. So if you start with domestically, absolutely, fragmentation is not just a theoretical possibility, but a reality. There's literally thousands of domestic cases where courts are grappling in very different jurisdictions and very potentially different legal contexts with difficult issues of causation, attribution, shared responsibility for what is effectively a global commons problem that is the climate crisis. And so you do have a lot of disparity in the way that domestic courts are approaching what are very novel issues when applied to climate in the climate context. So there are thousands of these cases. The Columbia Institute has done a wonderful job actually tracking them. So you can see most of these cases are in the United States. So it's very palpable, the notion of fragmentation when you're talking about domestically. And we're also witnessing a widening circle of potential accountability from energy companies to animal agriculture, food and retail industries, professional service firms. This signals that there's this going to be a potentially even more diversity in these opinions as different sectors interspacing with climate crisis and GHG emissions are kind of brought into what domestic litigation looks like. I think that's really the reason why my answer is so significantly different on the international plane. In the international plane, it's one more of a story of harmonization. And I think Nicola very ably kind of set out, even with these three advisory opinions, you see how the principle of harmonization has worked its way into these opinions, including and especially the ICJ opinion, which weaves seamlessly when it speaks to obligations under UNCLOS with the ITLOS decision from a year earlier. And in fact, when there was over 100 delegations of states and international organizations that appeared before the ICJ in the oral proceedings, and it was pretty remarkable as we were sitting there, we actually at one point started tracking how many times the ITLOS decision was being cited to the ICJ, and it was over 250 times. And if you look at the ICJ's advisory opinion, again, there's this harmonization that occurs. The Inter-American Court decision came out very close to the issuance of the ICJ, I think that's frankly one of the only reasons it wasn't as embedded, because there are also synergies between the ICJ's human rights obligations, descriptions, and the Inter-American Court. So you see that these entities, these international organs, are engaged in harmonization. So I think there it's a different story than I would say domestically.
Thanks, Catherine. That was really interesting. You talked about you mentioned the convergence that's happening at the international level, and I think we've seen in the advisory opinions how states can take an outsized role in helping to develop the law in that respect. I want to link that to what you mentioned earlier at the beginning of this session regarding the draft conciliation annex as another possible pathway for resolving disputes, and another way that states could also help further the law in this respect. Do you think there are features of conciliation that could make states perhaps more willing to engage in resolving their disputes, particularly in the climate change context?
Thank you for the softball question. My answers are resounding yes. And this may be an unpopular opinion, but I personally believe that the contentious context in which some of these climate change issues are going into results in years and years of contentious litigation, adverse, expert reports, fact testimony, et cetera, that doesn't get to the nub of how do we effectively as a global community mitigate GHG emissions and put adaptation in place for the most climate vulnerable states in the world. And that conversation, I think, could be quite well suited to conciliation. It's flexible, it's state driven, it can reflect different cultural, economic, developmental preferences. It's a context in which expert technical testimony can really be kind of brought to a fore. And if you look at some very good examples, for example, the Timor Sea conciliation under UNCLOS, it's quite powerful in bringing parties that are far apart into a middle ground and finding creative solutions. I would say perhaps even more powerful than traditional contentious litigation, which is driving towards reparations and which are important as part of the equation. But it's more impact on conduct when it comes to climate change that we need to focus on. And given the urgency of the situation, really need to be able to focus on it in a timetable that, again, does not lend itself in contentious litigation oftentimes. So I think there's a real power to conciliation. Sometimes you'll hear, well, at the end result, it's non-binding recommendations. How is that dispute resolution? We've seen time and again where conciliation procedures, even though non-binding, allow the parties to build trust, increase communication, strengthen their relationship, de-escalate differences, and actually get to political and legal solutions. So I think there's a lot of power there. And then the other aspect of it is that you can balance transparency and confidentiality in these bespoke proceedings so that, climate change is a public order issue. There's an entitlement and an importance in transparency for civil society organizations, the public at large, to understand how these disputes are being resolved. At the same time, confidentiality can help states actually get to those creative solutions by creating a space for discussion and negotiation. Conciliation can be a combination of both transparency and confidentiality provisions that allow, I think, very creative dispute resolution, which we all know climate change as an existential crisis really requires. So I'm very much feeling bullish on it. It's why Annette and I decided to co-chair the Blue Ribbon Task Force to really bring conciliation as a potential tool, a powerful tool, into the discussion about how we resolve the crisis that is climate change.
Thanks, Catherine. Those are definitely sounds like real unique features of conciliation as a dispute resolution process that might lend itself really well to these likewise unique features of climate-related disputes. Nicola, just turning back to you, you really helpfully laid out some of the really critical elements of especially the advisory opinions, especially the ICJ opinion, tying that to potential contentious cases and litigation going forward. What do you anticipate in terms of how those advisory opinions will actually shape states' litigation posture? Do you expect that they'll have a deterrent effect, or could they conversely encourage states to pursue contentious cases. I imagine that state responses will fall along a spectrum depending on national circumstances and strategic considerations, but could you share your views on sort of what that range of reactions might look like in practice?
Yeah, thanks, Crystal. I think there's as anything, there's going to be a range of responses here. And I would like to hope that the advisory opinions create impetus for stronger action by states, because we have a very clear articulation of states' responsibilities, and we have some very concrete obligations that are articulated with quite a degree of specificity. And that links to states' NDC obligations and what those mean and what that looks like. So states' obligations in the international arena, but necessarily what they're doing back home. And we would hope that this type of articulation leads to stronger policies on the domestic end. The advisory opinions are, as I said before, already being picked up in terms of domestic litigation in relation to government entities and government obligations. And so some of those points that we were discussing earlier around the relevance of the science and the role of the ICCC determinations and the role of customary international law are going to be picked up and are being picked up in those domestic decisions. And then at the international level, it'll be really interesting to see, picking up on Catherine's remarks, whether some of the most climate vulnerable states pick these decisions up, either in a more adversarial way or in terms of opening this door towards conciliation and discussion. And it could be through a formal conciliation process under the annex, which has been drafted. It could be through more discussion and negotiation. And there'll be a lot of careful thinking as to what is the best way to actually result in action quickly, which is obviously what is needed. So I just thought what might be interesting is just pointing to a couple of the decisions where this is already being picked up, and one of them is the petition that's just been filed in the last 2 months in the Inter-American Court by the original plaintiffs to the Juliana litigation in the US, which many of you will have seen, which is a new claim in the Inter-American Court, which is directly referencing the Inter-American Court opinion that came out earlier in the year, the Atlas opinions. And so that is now going to be litigated within that forum. There's another really interesting one in Canada, a constitutional challenge where we actually had a decision of the federal court there just in late September as well, which was a strikeout application against this constitutional challenge, which has been brought against the government there. And the court really carefully went through the findings of the ICCA advisory opinion and acknowledged the persuasive authority of the advisory opinion, and used reference to the advisory opinion to determine that it effectively didn't allow the current claims to proceed in their current form, but it did say that the claims could do so if reformulated, and so they actually allowed the plaintiffs leave to amend their claim to bring a claim that more closely relied on the customary international law position, which the ICCA opinion articulated. So we're already seeing these things evolve.
That's really interesting to hear. Thanks, Nicola. Just bringing it back to the sort of interstate, at the state level contentious cases type of litigation. You are a member of the ICCA panel of experts, and you personally also worked on the draft conciliation annex that Catherine mentioned earlier. As we expect more of these types of interstate contentious cases, and as we expect more states and more diverse range of states being pulled into these kinds of cases, could you talk a little bit about how the annex itself, when you were drafting it with the other panel members, how they would take into account, how it takes into account the different needs and circumstances of the states parties to ensure equal access to this method of dispute resolution?
Sure, and Catherine picked up on some of this earlier, so you can really see the flexibility of conciliation through some of the procedural options that the annex has, and so you know, there's a clear consideration of submissions by third parties that the Conciliation Commission can allow, so that you can get that broader perspective, as opposed to just the states that are appearing sort of formally before the Commission. There are provisions where you can balance the transparency and confidentiality obligations, and Catherine spoke to that too. So, you know, there are default elements of transparency, and there are also default protections for confidentiality for different aspects of the dispute. And I think that was something that the working group really grappled with, as to how to appropriately balance this, so that what is inherently a state-to-state conversation can be enabled, but recognizing the broader significance of these issues. So there's a really thoughtful balance between transparency and confidentiality in the draft articles. There are provisions to allow multiple disputes to come together for consolidation, so that you can be more efficient with a large number of states that might be involved on a particular topic. And then ultimately what the Conciliation Commission would do is issue a non-binding recommendatory award. So that's a very significant difference and a very significant attraction for states when they're deciding whether to enter into this type of process, is that the outcome is a non-binding award. So they're not bound by it, but it is going to be a significant recommendatory document that comes out of the end of that process. And the disputing parties must consider that in good faith, under the terms of the UNFCCC and Paris Agreement articles. And what the Commission can do to try and take that forward is that the Commission can suggest ways that the parties might fulfil their duties to consider that non-binding recommendatory award. And so the Commission can propose, for example, that they might undertake further negotiations on particular issues, or that they might report on steps taken towards implementation of that recommendatory award, or even propose, for example, an implementation committee if the Commission thinks that that's a useful thing to do. But it's deliberately designed to be very flexible and very focused on what is best for the states, and for the states to continue that conversation. And so I think that balance has been really carefully kept at the forefront of the deliberations on that annex.
Thank you, Nicola. That's really interesting insight also into the process and the thinking behind those specific features that you highlighted. I'm going to turn the floor over now to Camille and Nusrat and Ilana to take things forward. Camille, please.
Thank you, Christelle. I have to commend you for an exciting first part, and the numbers of participants have been keeping on going up. So we'll try to keep that momentum for the other part, and we're going to focus now on whether the dispute settlement mechanism options you presented, conciliation, litigation, domestic or interstate, are well suited to resolving the issue of climate reparations. And so I want to turn the floor now to Joy right away. So you work with the Grantham Institute in London at the LSE, and I'm waiting every year to read your reports and your findings on climate change litigation. So can you present a bit your latest findings on that trend that everyone hears about but doesn't necessarily are privy to? So which themes have been explored in those cases, and what forms of relief are the parties seeking? If you can elaborate on that to get us started. Thank you so much.
Thanks, Camille, and thanks everyone for having me, and hello as well from Belém, where Camille and I are both. But yes, so I'm here to share kind of an overview of the Global Trends in Climate Litigation 2025 snapshot, which is no longer a snapshot because it's getting much longer every year. And it's a report made by the Grantham Research Institute at the LSE, which gives us a clear picture kind of what's been happening the year before, and updates on the first 5 months of the year when it is released. And it gives us a clear picture of how people, communities, companies, and governments all over the world are using the courts to shape climate action. And very interestingly, it was mentioned earlier as well, this discussion of the best available science 1.5 as well as customary law are also things that we have seen that are very much seen in these reports. So I will send in the link to, I guess, the CISDL group in order to share that to the attendees. But essentially, the report has 4 main parts. So part 1 looks at the big picture. How many cases exist and who is bringing them to courts. And we see that in 2024 alone, over 200 climate cases were filed, which brings the total to almost 3,000 cases across 60 countries. And we know that most of these cases have been filed after 2015, but many have been filed even before then. And more than 80% of the new filings were strategic in nature, meaning they were not just brought in to win a case, but also to influence broader climate policy, influence public perception, etc. And we see that the US continues to be the most active with 164 cases. But we also see political pushback, and that's something we talk about as well. So non-climate aligned cases. We saw that 60 new cases used arguments that were against climate goals, which challenged the authority of governments to regulate emissions or to contest sustainability efforts of companies. And one new thing that we did for this year, which was led by Joanna Setzer and Catherine Hyam, is looking at analysis of cases that reached Supreme and Constitutional Courts, so apex courts. And we've seen that since 2015, almost 300 cases have reached these highest courts. And so it's really interesting to see. I think the attention moving forward would be on implementation. And so that's going to be something that we will be looking forward to as well. So that's the big picture. Part 2 looks at cases that support stronger climate action. So these includes lawsuits on government ambition, on corporate framework, corporate emissions, turning off the types. A well-known example from a case that was decided last year was Milieu v Shell in the appeal, where the court told Shell that it had to cut emissions across its whole business, even though it did not say the exact number by which it had to do so. Another example, which was groundbreaking and something that we all remember from May of this year, was Yuya versus RWE. So Sanu Yuya is a Peruvian farmer from the Andes who sued German utilities company RWE to help pay for the costs of melting glaciers that threaten his hometown in Juarez in Peru. And while it was dismissed on the basis of the fact that it did not meet the legal thresholds for risk, it did agree in principle that companies can be held responsible for their share of global emissions. And these are all landmark steps in holding corporations accountable for their contributions to climate change. And then interestingly, which I think is one of the most, poignant parts of the report, is cases that push back against climate measures. Again, the climate non-aligned cases or non-climate aligned cases. So these include lawsuits that argue that climate regulations go too far or create unfair burdens to corporations. And much of this is in the US, but there are also green versus green cases, for instance, where communities who support climate action overall, but oppose specific projects like wind farms or transmission lines because of local impacts to their communities. And here, the Global South plays a major role. Nearly 60% of all of these cases were filed since 2020, which shows rapid growth. And unlike in the Global North, many cases are actually brought by governments, which is something that we saw in the deforestation case in Brazil. And again, as mentioned earlier, the advisory opinions played a very crucial part in the global trends. We didn't really mention as yet, as of writing, the ICJ and the ICCA advisory opinions that will come out in the next version, but the ITLOS provided very important pronouncements as well on the obligations of states. And then finally, part 4 of the report looks beyond the courtroom. We look at how climate litigation is changing how governments make policy, the broader financial impacts of climate litigation, the risks to litigation and firm value, how companies are planning for their future, and how financial institutions are assessing risk. And this is something that we're seeing perhaps with the case of Milieu FNC versus ING, where people are now also looking at financial institutions financing fossil fuel companies. And as I said earlier, perhaps an important thing is to look after courts decide. So courts in Europe, people everywhere are watching closely as Switzerland works perhaps to implement the ruling in Clima Signorinen, where, as we all know, a group of older women won a case arguing that weak climate policy in Switzerland were endangering their health and their lives. And so this is a very, very brief snapshot. Again, I've sent it to the moderators to send to people in the room. But the message of the report is simple, and that it's that climate litigation is becoming a major force in shaping our world and in shaping our policies. It's growing, it's diversifying. There are more themes that are being explored at the moment, and it's definitely influencing governments, companies, and even markets. But what really matters truly is whether the decisions leads to real change on the ground, because that's when we know that we're doing something right. And so it's helping define how we respond to the climate crisis in the courts. And so we see that, the solution to the climate crisis is not definitely something that we can just see in the courtrooms, or in the convention rooms, in the conferences, but in the courtrooms as well.
Thank you so much. I wanted to hand the floor to Nusrat, maybe for some comments and another question. Thank you so much for joining.
Hi, thank you so much for having me, and thanks to Joy for a nice overview on the report. I think it will help all of us to go through further details. Based on your presentation, I would like to add a little bit about the Lilo case. That yes, it sets a significant precedent regarding the corporate responsibility. At the same time, I think it actually gives the green light for transboundary climate harm. This case has a lot of significant contributions to climate litigation concept, though it has been dismissed. It was dismissed, but I think the judgment will have further impact and implications in the future litigations. And I think the judgment gives the vulnerable individuals and communities a chance to hold the polluters responsible for climate harm. So based on this, I just want to say that we know that climate litigation in the global north has a longer history with established legal framework. In contrast, climate litigation in the global south is relatively new and emerging trend. So in this context, what is I want to know from you, what are the distinctions and similarities between litigants from the global north and south when it comes to demands?
Thank you, Nusrat. Yes, that's a really important question. As I said earlier, litigation from the global south is really, really growing, and we're learning a lot even in the very early stages. One thing we've seen is with that in the global south, a striking feature is who brings the cases, because in the global south, even governments, public prosecutors, and regulatory bodies play a central role. And their demands often focus on enforcement and compensation for localized harms. For instance, like in the case in Brazil, where prosecutors sought damages linked to deforestation and its climate impacts. And then when it comes to sources, so global south litigators usually focus on constitutional rights and environmental laws as their central legal tools. In the global north, most cases are brought by NGOs, citizens, and coalitions, and demands tend to push towards systemic policy change, including stronger national emissions targets, better climate governance, or more ambitious mitigation targets, because those are things that global north countries are more have more responsibility in anyways with regard to mitigation. And the focus of the claims. So most of the global north litigants demand scrutiny of scope 3 emissions, while in the global south, even when climate change is not the central issue, it often arises because there are cases about land use, pollution, forestry, environmental justice, which reflects how climate impacts are deeply intertwined with local needs and local livelihoods. And so these are the differences, but there are plenty of similarities across regions. Number one, as I said earlier, it's now overwhelmingly strategic everywhere. And now both regions are increasingly turning their attention toward corporate corporate actors, knowing that corporations are also playing a big role in making worse the challenge, the climate crisis in front of us. And finally, litigants are leaning on rights-based frameworks, where they ask courts to recognize that inadequate climate action threatens fundamental human rights. And so, yes, there are a lot of differences with regard to who they are, with regard to their causes of actions, but generally very, very strong trends towards rights-based litigation, strategic themes, as well as asking the courts for corporate accountability as well. And this is something we'll see potentially more even in the future with the advisory opinions.
All right, thank you so much both for your insights, and hopefully we're going to have some more conversation in the Q&A. But thank you, Joy. Thank you, Nusrat. And then I suggest we move to Maria's presentation on the ICJ's advisory opinion. We've discussed it already, but you've been working specifically on how to allocate responsibility between states, because one issue that's dear to your heart, at least you've been researching on, is how might states share responsibility for climate reparations in a way that's both fair but also consistent with international law. So if you want to share your thoughts on that, that would be great. And then we can continue the conversation with Nusrat and Elena. Thank you both for joining. And then, yeah, please, you have the floor. Thank you.
Thank you very much, Camille, for your question. And I want to also extend my gratitude to the organizing members of this day and to the sponsors. So to answer your question, let me briefly refer to what the ICJ gave us and what it left open. When addressing the legal consequences arising from breaches of the primary obligation, the court based its analysis on the customary rules of state responsibility and considered that these rules were sufficiently equipped to address issues of shared responsibility. It acknowledged that there could be potential issues with regard to attribution and causation, but it stated that this could be addressed on a case-by-case basis and did not set out any detailed formula on the apportionment and allocation of the responsibility among multiple states. I tend to agree that in the advisory setting, the court did not need to go any further into the issues of apportionment and allocation. However, I feel like the court did not fully grasp the practical difficulties that may arise in legal practice when there are multiple and cumulative causes leading to a single and indivisible harm, and without a clear pathway of how victims can access justice to claim full compensation for this climate injury. I think that we will be missing many of the harm, or most of the harm will be uncompensated for victims. So the problem here is not whether there could be shared responsibility of several states contributing to a single wrongful conduct, because that is indeed, it is reflected in Article 47 of the Articles on State Responsibility. Rather, the problem is that in the context of climate change, we find ourselves with multiple actors, both states and non-state actors, who have somehow contributed to distinct wrongful conducts, but also have undertaken lawful activities that nonetheless may result in a single indivisible injury. In those cases, I think that the law of state responsibility cannot fully answer the question of who bears responsibility for the losses and damages that are caused. So for the right to full reparation to be meaningful in practice, victims must be able to claim the full amount of the full breadth of the compensation from any responsible state. And while the secondary rules seem to point in that direction, the general regime of joint and several liability or joint and several responsibility is not clearly recognized under general international law. Even if we consider that this system of solidarity among responsible states is the most efficient regime for victims to get full compensation, there are essential safeguards and practical difficulties which will need, from my view, to be envisaged. First of all, a right of recourse should need to be preserved among states, which would thus lead the way to allowing contribution claims among responsible states. And From my perspective, a general system of contribution between states is very difficult to attain in practice, given the jurisdictional constraints that are inherent to the international legal order. But to me, it is the only way to prevent that victims suffer from undercompensation and the fragmentation of claims that actually I think that Catherine referred to earlier in the discussion, while permitting states to recover a fair share from other responsible states who have contributed to the single and indivisible harm. The second element that I think is worth noting, and I am mindful of my time here, is where to set the limits of joint and several responsibility, which is in turn related to the limits of legal causation. States can be expected to bear responsibility for injuries that they can reasonably foresee and that are not too remote. This might lead us to a rather strict and objective assessment of when the realization of the risk can reasonably be expected from the state. But again, I think that it is the first possible formula that I can think of to prevent and hinder claims. And this is, of course, an imperfect solution, the one that I gave you, Camille, I'm aware of that, and that the impact that we see today from climate change, most of it, or some of it at least, is irreparable because it comes from lawful actions or omissions that have come over extended periods of time. But I think that these discussions can lead to some pathways to provide victims with suitable remedies to at least recover some of the injuries that they have suffered.
Thanks, Maria, for your nice presentation. I have a follow-up question for you. So, based on your presentation, establishing a state responsibility actually requires determining causation, and climate science plays an important role in determining causation. So, how should climate science inform the determination of causation and the apportionment of reparations in climate litigation, especially considering the International Court of Justice reliance on the IPCC reports? What is your opinion? How should go?
Thank you, Nusrat. So picking up on what Nicola referred to earlier in its intervention, I think that indeed the court relied on IPCC assessments as the best available science to calibrate the primary obligations of states. And my answer to your question would be that climate science should not only be relied upon for the purposes of establishing the factual causation, but also it should actively guide the test for legal causation. So what do I mean by this? From what the court said, it seemed like we are moving towards a system of risk assessment and due diligence in the climate change domain. States are required to prevent climate injury in accordance with their capabilities and in light of available science. So states, therefore, can bear responsibility for failing to take measures that they should have been required to take and that have led to other actors, for instance, corporations, to undertake activities that have caused climate injury. From my view, this architecture might be at odds with the general requirement of directness in causation that is generally required for the duty of reparation to arise. The current status of climate science will not likely inform us of whether this consequence would have not occurred but for that omission of the state. But what science will tell us is whether the injury was a foreseeable consequence of a risk that the state should have averted and has not. So my take from this is that the analysis that court gave from primary obligations should be informed by elements related to foreseeability, proximity of the risk, reasonableness of the risk when analyzing causation. When the establishment of factual causality is unclear, as it is the case of climate change, the law will give us the threshold of when to consider that an injury can reasonably be linked to an action or omission. And this is where science comes in to evaluate this reasonableness. So for instance, and I finish with this, if IPCC assessments at the relevant time showed that there are probabilities of sea level rise, heavy rainfall within a given region, those findings can inform what was reasonably expected and foreseeable for states, and therefore will guide the diligence of states that for the actions they had to plan for. In that case, if this risk has not, which has previously been identified, has not been averted by the state, then the legal causation would be satisfied. And that is my take from how climate science should be used in this regard.
Thank you
Thank you
so
so
much.
much. Thank you, Maria. Thank you, Nusrat. I would like to give the floor to Alana now. Thank you so much for being so patient, but I'm sure you have comments to make and then perhaps some questions to the panelists. So take it away. Thank you so much.
Thank you to the organizers and of course the hosts of this panel for creating a platform for timely discussion, and indeed the panelists for their contributions in light of the advisory proceedings of ITLOS, the Inter-American Court of Human Rights, the ICCA, and I would add the upcoming advisory opinion on the African Court of Human and People's Rights. And within the context, of course, of conciliation and dispute settlement in addressing climate reparations. Both the conciliation and the potential role of dispute settlement, both the Inter-American Court as well as the International Court of Justice reference reparations in the corpus of their opinions, and the contribution by our panelists particularly encourages reflection on the topic that is urgent and emerging in the global South, especially in particularly vulnerable states. The existing body of critical international legal scholarship on reparations, especially within the context of historical economic reparations, is limited. And therefore, the recent developments will be critical for both states, peoples, and communities impacted by climate change. One of these areas is that of the Caribbean, which includes 16 small island developing states, stretching from Bahamas in the north to Suriname in the southeast, and which have been recognized by the Inter-American Court as a region of special vulnerability, as it is ground zero for the climate emergency and vulnerable to climate risk, including loss and damage. The Caribbean's geographical vulnerability to Category 5 Cape Verde type hurricanes, such as Hurricane Melissa in 2025 and Beryl in 2024, have decimated states such as Jamaica, the Grenadines of Grenada, and St. Vincent. And they have raised calls for novel approaches to the complex mix of geography, history, and economics in a region besieged by exploitation of colonial power since their discovery in 1492, as well, which has included the annihilation of indigenous peoples and almost entire repopulation of enslaved Africans, and subsequently the use of indentured servants from Asia and Europe. Against this background, I would like to ask the panelists the question: what is the potential for litigation at the domestic and international level to support climate reparations and repair harm experienced by communities most vulnerable to climate change, such as Afro-descendant peoples in the Caribbean? Thank you.
I guess.
Joy, yeah.
If you don't mind, Maria, I can go ahead. Yeah, so what essentially the three advisory opinions and the future advisory opinion of the African Court of People and Human Rights has been telling us is that there will be a lot more litigation. Potentially, this has set the stage for plenty more litigation, which might use reparations and the context and the concept of loss and damage in their pleadings. At the domestic level, courts everywhere in the planet are increasingly being asked to protect its people from climate impacts using constitutional rights. And for Afro-descendant communities, these legal tools can provide a path to demand stronger protection as well as even compensation for when governments fail to act. Domestic litigation is also interesting because it can target private actors. And that's what we've seen in the case, for instance, of Milieu Defensie in the Netherlands and UIA versus RWE in Germany, where courts have increasingly shown that they were willing to hold hold major emitters liable and that they should pay for climate damages. And then on the international level, this potential is even broader and I guess more salient because human rights bodies such as the Inter-American Court of Human Rights have strong histories of protecting indigenous peoples and peoples of Afro descent. So their decisions have recognized cultural rights, land rights. And so applying these principles to climate impacts would open the door to a form of climate reparations that are grounded in human rights. And recent developments are strengthening this pathway. Again, as I said, the ICJ, the Intl, and the future advisory opinion on the African Court could be very, very important to show reshape global expectations around the question of reparations. Just a point that litigation, I don't think will ever replace political solutions or global financing mechanisms, but it can bring something I think more essential, which is recognition, accountability, and work in creating enforceable obligations. At the core of it, it can help governments to protect vulnerable communities, and even broader, it can change public perception of what it means to live in the world that is currently facing a climate crisis that is existential to all. And so climate litigation offers real potential to support climate reparations for Afro descent people with Afro descent in the Caribbean, not only through compensation, but also through strengthened rights and safer futures. And, a long overdue acknowledgement that this is historical injustice and that it should be accounted for.
Thank you so much, Joy. So I'm mindful of time. So Mari, maybe if you have additional comments, you could pick up in the Q&A if you don't mind, because I'd like to give a chance to everyone to ask questions on the chat. So Rihanna, Christelle, if you want to take it away for the last bit of the panel. Thank you so much all. And then we'll circle back to conclude afterwards, but go ahead. Thank you all.
Great. Yes, I echo the thanks to all of the panelists. If you do have a question, I think you can submit it in the Q&A box at the bottom of the screen. Just send it to us that way. I'll kick us off with one for Nicola. I think, can you talk a little bit about how conciliation and other maybe non-adversarial mechanisms might address the issue of reparations, just to tie together these two topics? Does conciliation have a role to play in ensuring that reparations reach the communities that have been most affected by climate change?
Thanks, Rihanna. That's a really interesting question. And it's something that is not yet determined. So conciliation hasn't been used in the climate context, and it's very much something that is now on the table. And as Catherine said, because of the alignment of the advisory opinions, there's a really good reason for states to be thinking even more carefully about how they might use conciliation. And one of the ways in which it could be used is to enable that conversation with groups, with community groups, with Indigenous groups, for example, because conciliation can be so flexible in its procedure. And that's one of the advantages that we may see states thinking that this could be an effective way to provide a forum to allow some of that discussion to happen in a way that would be separate to a domestic court challenge, for example, which is much more adversarial, or separate to an international level adversarial challenge. And you could actually allow a conversation to happen which was more facilitative of sort of a sort of collaborative resolution as opposed to something very litigious. So when you think about reparations, it's challenging because that is necessarily a sort of a litigious angle that you would expect to follow. But the conciliation process could allow some of the discussion around some of the thornier issues that will need to be worked through before getting to the point of actually considering whether reparations might be something that a particular state is going to entertain or not. So I think that there's a bit of a path to be walked at the moment.
Thanks, Nicola. And thanks, everyone. The questions are all coming through now, so we'll walk through one by one. Let's start with the first one from Debevoise, the Chief Legal Advisor of Green Plinth. What sanctions are enforceable in international law for compelling compliance and deterrence in climate change breaches apart from conciliatory and ADR mechanisms, which at best attract damages? Reactions to this. I might just open up the floor to all the speakers. I think to whoever has a reaction to this, I think it does touch on sort of all the aspects that, quite a few aspects that the various speakers discussed. So anybody? Nicola, I was wondering whether you have a reaction to the second part of that question about conciliation at best attracting damages. Maybe you could speak to that.
Again, I think the benefit of conciliation is that it can go far beyond damages. So damages is a very sort of specific focus that will ultimately require state decision or a state being sort of forced to do so at a domestic or international level, which I think we all have to recognize is you know, it's a very challenging proposition. And so thinking about how conciliation or ADR mechanisms might be able to facilitate other solutions, whether it's increased regulatory engagement or increased state action at a very local level, responding to community need, helping with the adaptation, sort of empowering greater mitigation, empowering cooperation between states, which was one of the themes that came through the advisory opinions. To my mind, there's a lot of positive engagement that could be had on all of those topics, which might get faster action at a state level to mitigate emissions than the very complex question of solely focusing on damages, which certainly could assist on the adaptation debate, but won't assist on the mitigation debate. And I think that one of the concerns I have in working in this area is that we move, that the international community moves only to focus on adaptation when really the international community needs to look at both mitigation and adaptation together. And I think the conversation around damages can push us away from mitigation, which is still, as we approach 2030, and this call from climate science to mitigate emissions and how significant that is for every degree we go over 1.5. That's where I worry that the international community's efforts sort of need to balance the demands that we have both on the mitigation and adaptation side.
Great, thank you. I think this may build on that point a bit. So M. Gehring asks, is there an enlarged space for ADR in climate litigation? And I wonder if what this is getting at is really, can you use arbitration and conciliation and mediation in the domestic context or alongside climate litigation, maybe to address, as you just said, both the mitigation aspects and the reparations aspects? Do you have any reactions to that?
It's a great question. It's something that the international arbitration community has been thinking about for quite a long time now, and certainly the increased use of arbitration to resolve climate-related disputes is really well documented and well known, and you see that both at the international level in terms of the ICCA investor-state cases where arbitration is being used to resolve challenges where states have pulled back from measures that they previously put in place to encourage mitigation efforts, etc. But there's also a really interesting conversation about the use of arbitration for resolving private commercial disputes that touch on climate issues. And ultimately, those disputes are often project-based disputes that drive off a regulatory change that is facilitating renewable energy development, for example. And there's been a lot of interesting debate around whether those private commercial arbitrations should increasingly acknowledge the public discourse around climate, and whether those private international arbitrations, for example, or domestic arbitrations should actually be able to engage with properly with community demand for transparency and recognition of the IPCC decisions for recommendations, for example, and so that I think is all really positive content and is happening. In terms of litigation against states or corporates and whether you could bring ADR into that, again, it's very fact dependent, but I think the kinds of issues we've been talking about that arise out of the Conciliation Annex at the international level, all of those same points can be made at the domestic level. So the fact that ADR has that sort of more flexible process approach and can bring in other voices, that same model could be used in a domestic context too. But I haven't seen it. I haven't seen a lot of examples of it yet, but I think that's because the temptation is to go straight to litigation rather than to think about ADR. And we've seen that in lots of different jurisdictions. The US is probably the best example where it's been a really strong litigation focus and perhaps not so much thought put into how ADR might be used at the domestic level.
Really interesting. Thank you, Nicola. The next question from Mark Anthony Bennett. How can climate reparations be secured for Black River, Western Jamaica, or after Hurricane Melissa, especially considering the role of historical emissions from developed and colonial powers in increasing hurricane intensity? I feel like maybe Joy, this one might be for you, or Alana.
I'm happy to have maybe Maria, because I did answer the question earlier of Alana, if she's happy to take on that. That's okay.
Yes, probably. Well, Alana is probably better positioned to answer this question, I would say. But just as a brief overview, I would say that climate reparations for Black River and after Hurricane Melissa, I'd say that in emergency situations are unlikely to be secured through litigation alone for sure. And in fact, it might be better pursued through political and institutional reparations scheme that is informed by the population, the affected population themselves. It is true that, of course, there is a historical background that should be taken into account, but that is also why mechanisms of loss and damages are there, and they have to actually serve these purposes of pursuing places which have been gravely affected by emergency situations such as Hurricane Melissa. So I would say that the first thing is to try to give financial funding to people who have been directly affected, regardless of whether litigation or conciliation may be pursued afterwards. And probably Alana has something to say here.
Yeah, thank you, Maria and Joy. Excellent contributions on this. I think what I'd like to add is, yes, reparations within the context, and I think within the context we've been thinking in the Caribbean cannot only solely be a litigation process, but it has to be political as well as maybe I would even say a bilateral potentially process. What I can say, at the level of the Caribbean community, there is a movement towards reparations for the issue of slavery. I think what needs to be linked, what needs to be developed more is within the context of climate reparations per se. The other thing I add and wrap up with is that in the aftermath of last year's similar Category 5, which decimated the Grenadine of Carriacou and some other Grenadine, Union Island and so on, the governments of Antigua and Barbuda, St. Vincent and the Grenadines and Grenada would have approached the UK government with a proposal for a sort of Marshall Plan in the context, given that the United Kingdom was the major European power of these states. And again, that there are several proposals, including the Bridgetown 3.0 initiative, but some of these are multilateral, many of these will be bilateral. And many of the things Maria referenced in terms of causation, if we move towards the litigation aspect, will arise. And that, I suspect, will be the proof of the pudding. So I'll just leave it at that for now.
Great, thank you both. And I think we have time for one more question. We have one from Mohammed Nizamani, sorry. How can we deal with countries that receive funds for climate issues but spend them on other problems? So I suppose this is asking whether there are avenues to bring claims for misappropriation of climate financing. And I'll open up that to the whole panel if anyone has thoughts.
I can take a first stab, and feel free anyone to join in. There are always potential pathways for holding corporations accountable, right? But then I think that one of the things that are discussed in the international negotiations is, for instance, how to make sure that funding, for instance, for the fund to respond to loss and damage, have transparent mechanisms with regard to monitoring, as well as reporting to the fund responding to loss and damage where the money is being spent. So that's kind of proactively, but in the past, when things of the same nature have happened, I think there's always room for holding governments accountable in litigation, or perhaps in real respect in countries' respective mechanisms to hold government officials accountable for say misappropriation of funds. But feel free anyone else to jump in.
Just a really brief comment. I think there's sort of two points here. One is accountable at the international level when that funding is coming from an international body, and the duty is very much on that international body to be making sure that it's getting that reporting and holding that state accountable for funding that has come to it. Another option is obviously domestic level accountability and using domestic measures in terms of disclosure of public information to try and shine a light on that and through domestic channels, and that will differ as to how effective that might be in different countries. But I think the primary focus has to be that the institutions providing the funding, and there's a whole range of different institutions with different governance structures in place, that they make sure that accountability is baked into the funding mechanisms, and that there are real consequences if it's not being used in the way that they're anticipating. Because otherwise you undermine the whole system, which is what we see in some of the COP media that we can see at the moment.
Great, thank you both. So with that, I think we have time for brief closing remarks. Crystal?
Yeah, I wouldn't call them closing remarks, but maybe I can quickly wrap up and thank all our speakers and participants for such an insightful and forward-looking exchange. We heard how the advisory opinions and those to come have clarified and will hopefully continue to clarify states' obligations, and how they're already influencing litigation strategies and claims worldwide, both at the domestic level and the international level. And as Joy and Maria highlighted, those dynamics, particularly the growing diversity of litigants from both the global north and south, underscore the need for dispute settlement mechanisms that are inclusive and adaptable. And we also heard how conciliation can play a very transformative role in this respect. In particular, its flexibility allows it to reflect sort of the varied circumstances of states, and also to incorporate different forms of evidence, which is another theme that we talked about today, and perspectives. and also to promote dialogue where formal adjudication sometimes may entrench division. There is the draft conciliation annex we discussed earlier that really offers a concrete starting point for states to give full effect to these additional procedures envisioned under the UNFCCC. And in light of this evolving jurisprudence that we talked about today, the urgency of implementation that step has never been more timely. And more broadly, today's conversation also reminds us that conciliation complements litigation, adjudication, but also political efforts. And together they allow for accountability, cooperation, and implementation that can advance global climate goals. At the same time, law's power in the climate arena lies not only in judgment, but also collaboration, and building trust through different mechanisms really is essential to delivering real progress. So on behalf of our chairs and all our moderators, thank you again to our speakers, our partners at CLGD, and also everyone who joined us today. Camille, do you have anything else to add?
Not just to thank you very much, Crystal, Rihanna, for your dynamic moderation, and then to our speakers for connecting very late at night or during COP. So thank you all, and hopefully you can access the reports and get in touch if you have further questions or want to collaborate. So thank you all again. It was an amazing presentations, and look forward to collaborating with you all in the future. Thank you.